This is your daily dose of all things royal. Welcome back, my gorgeous, good looking friends. Let's go back to June 27th, 2024. That was the day it was announced that Harry was being called out by the UK courts for deleting messages. Now, if you are like me, you read these articles and kind of was a bit confused as to what was really going on. And the frustrating thing about these reports is that you don't necessarily know if you could trust what's being written, if they are indeed telling the truth. So when People magazine posts an article about this, I'm very skeptical of taking it at face value. And of course, when this story broke and trying to get some kind of semblance as to what really happened here, we see the news of Prince Harry being awarded this Pat Tillman Award, thus causing much controversy and distraction away from this. So, what then proceeded to happen was another fire being ignited over the controversy surrounding this award. And we saw how that backfired on them. But at the same time, it did distract away from Harry deleting data. But what I don't understand is why did they choose to release this information on June 27th when the actual judgment wasn't posted for the public to see until July 5th? Why didn't the media wait until it was posted for everyone in order to write about it? I'm assuming that this judgment was given to both legal teams, and then the legal team for NGN passed it over to the newspapers. See, it doesn't work like that here in the United States. Everything is posted to a database, and that is for journalists to go on their own to find it. Here in this case, I feel like the media has an advantage in pushing a narrative or positioning a narrative before the actual public can see and judge for themselves the original source. So what I want to do today is go through with you this 12-page document that was given based off of these deleted messages and what really actually happened and what the justice actually said about it. And the reason why I want to read this out is because it helps me get a firm handle on the current situation and what exactly happened here in order to be able to talk intelligently about it. So for our purposes here, I will substitute Prince Harry's name for wherever it says claimant, and for the defendant, I will substitute and put NGN. Okay, let's begin. Judgment by Mr. Justice Fancourt. Number 1. This is an application issued on April 4th, 2024 by NGN for orders for specific disclosure against Prince Harry. The application concerns disclosure of documents relating to an issue of knowledge or constructive knowledge of Prince Harry of possible unlawful information gathering other than voicemail interception at any time prior to September 27, 2013. In July 2023, I gave summary judgment for NGN on Prince Harry's claim for misuse of private information by voicemail interception and accessory acts on the grounds of limitation. I refuse summary judgment on the remainder of the claim on the basis that issues of knowledge or constructive knowledge relating to other kinds of unlawful information gathering alleged by Prince Harry had to go to trial and could not be determined without a full evidential picture of the state of Prince Harry's knowledge of matters relating to unlawful information gathering at or before that date. One of the most important issues at trial, on which the burden will lie on Prince Harry, will be whether he did not know and could not, by the use of reasonable diligence, have found out enough about the remaining allegations of unlawful information gathering to appreciate before September 2013 that he had a worthwhile claim against NGN. That is a paraphrase of the legal test in Section 32 of the Limitation Act 1980. I'll refer to it as the knowledge issue, but it is not limited to questions of Prince Harry's actual knowledge. I think what's really important to understand here is that the whole purpose of this judgment was based off of an application that NGN had submitted in order essentially to do a type of discovery. The whole goal of this exercise is to find out whether or not Harry had knowledge within the window of what we call here statute of limitations. Because the challenge in this court case right now is that Harry didn't find out later that unlawful activities of gathering information was going on, hence the reason why it wasn't filed until later. And what NGN is trying to do essentially is point the finger and say, look, he knew about what was going on, but he chose not to file a lawsuit. Why is he filing a lawsuit years after? And that's where they're trying to figure out how to get this case dismissed. The question of the adequacy of Prince Harry's disclosure relating to the knowledge issue has been debated back and forth in correspondence since July 2022, albeit rather sporadically. There were large gaps caused both by delays by Prince Harry's lawyers in responding and by NGN not pursuing the matter, in part at least because of other applications, such as the strikeout application and the amendment application, which overtook the question of disclosure to some extent. I am not really interested in the disagreement between the parties' lawyers about who is to blame for the slow progression of the issue. What I'm concerned with is whether the trial of this issue will be fair to both parties, given the apparent paucity of disclosure by Prince Harry to date relating to the issue. The issue was, of course, cast into sharper focus after my ruling on the summary judgment application last summer. Since that time, there have been the following letters written and steps taken. First, a letter written on behalf of NGN on November 28, 2023, setting out claimed inadequacies in Prince Harry's disclosure and seeking disclosure in relation to the knowledge issue. Then on February 23, 2024, Prince Harry's lawyers replied to that letter. On March 8, 2024, NGN's lawyers wrote again asking for confirmation about various matters to seek to clarify how Prince Harry's lawyers had gone about the exercise of Prince Harry's specific standard disclosure and requesting searches using a set of identified search terms. On April 4th, 2024, without answering the letter of March 8th in detail, Prince Harry's lawyers offered to carry out a search of one email account, which had been identified as a result of the questions that were being asked, the SJPKP account, and accepted that identified search terms would be used for the search. Now, let's all remember that Prince Harry's lawyers and Prince Harry were hoping that NGN was going to cave and give out a settlement. This was the goal all along, but NGN is like, no, we're going to see this out, and riding the wave, calling Prince Harry and his lawyers bluff. And what we're seeing here in this little exchange is that letters were being written back and forth, and Prince Harry's lawyers ended up dragging their feet on this. On the same day, that April 4, 2024, literally an hour after the letter was sent, NGN issued the application that is before me now. Prince Harry's lawyers did eventually respond to the March letter on May 3rd, 2024, but not in a way that was entirely satisfactory. As a result of further correspondence since then, different issues about further sources of documents have arisen. For the first time on June 11, 2024, it emerged there was another large group of documents that have been provided by the royal household to Prince Harry in 2020, of which Prince Harry's lawyers were wholly unaware. There has been some movement on both sides. Prince Harry's lawyers have not yet concluded the review of the positive hits obtained as a result of the search of the SJPKP account, despite. So here is the million-dollar question. How did they find out that there were troves of data that was given to Prince Harry in 2020 by the royal household? So what had happened was the royal household gave Harry, on his way out the door, a whole bunch of data, probably saying, here, these are your files that we are separating from our server so you can carry them over to Montecito for whatever business that you're conducting. So that SJPKP account now makes more sense that it would represent St. James Place and Kensington Palace belonging to the royal household. Mr. Sherborne's attempts. There is no evidence of what that unfinished exercise has produced. No documents have yet been disclosed. The original order that NGN sought on this application has undergone some significant changes as a result of recent developments, including, most recently, a letter from Harbottle and Lewis, lawyers for the royal household, which was received only yesterday. At the same time as seeking to pursue a search or production of documents held by the royal household and by Harbottle and Lewis on behalf of Prince Harry, NGN has now issued non-party disclosure applications against representatives of the royal household and Harbottle Lewis, which indeed was what Prince Harry's lawyers suggested in their evidence on this application NGN should have done. Harbottle and Lewis, on the other hand, have suggested that the application against Prince Harry personally should be pursued first. The non-party applications are not before me, but some of the relief sought overlaps with the relief sought in this application. And this is now how the palace has gotten involved with their lawyers, Harbottle and Lewis, of which NGN had sent letters to them saying that they are looking for this kind of information. And rightfully so, the palace is like, no, we have nothing to do with this guy, and have been pushing back, also dragging their feet. The royal household doesn't want anything to do with this. I mean, can you blame them? As with everything in this litigation, the evidence and arguments in support of and against the application have been produced at some length. The application was supported by 46 pages of evidence from Ms. Mossman, and there was then 21 pages of response from Mr. Batten. Miss Mossman then replied in a further 26 pages, and Mr. Batten took the opportunity to have a further say, justified in this case by very recent developments in 6 more pages. I had over 50 pages of skeleton arguments to help me, and I had time to read all the evidence, correspondence, and the skeletons in detail. I had further helpful submission this morning from Mr. Hudson, Casey, and Mr. Sherborne. So understand these people just mentioned are Prince Harry's lawyers. The result, in overall terms, is this. I have real concerns that disclosure relevant to the knowledge issue is not being dealt with adequately by Prince Harry's lawyers. The majority of the search for and selection of documents to disclose has been dealt with by Prince Harry himself in California. Mr. Batten suggests in his witness statement that Prince Harry is an old hand at dealing with disclosure as a consequence of his Mirror newspaper hacking litigation claim. But the knowledge issue did not arise against Prince Harry in that case. The knowledge issue is a subtle one. It is a broad disclosure issue because the state of Prince Harry's actual knowledge about any form of unlawful information gathering, the conduct of NGN's journalists, and what any private investigators did is important, but it is not the end of the inquiry. Knowledge of matters other than the type of unlawful information gathering remaining in issue in this claim is potentially significant, as well as other types of unlawful information gathering that are not directly in issue. So essentially, the justice is scolding Prince Harry's lawyers for leaving it up to Harry to go ahead and haphazardly go through and do these searches without giving him any type of guidance. And they were wrong to expect Harry to know exactly what this knowledge clause is in trying to address that aspect of it, showing that he really did not know about this information until later on. And that's exactly where the justice is calling out these lawyers for pretty much dancing around it and ignoring it and not fully addressing it head on. Sometimes I have the impression in this claim that even Prince Harry's lawyers don't seem fully to grapple with the knowledge issue, at least the constructive knowledge aspect of it, despite its having been spelt out in NGN's correspondence and explained in my judgments. So it would not be at all surprising if Prince Harry himself did not fully understand or grapple with it. Perhaps the position instead is Prince Harry's lawyers do understand it, but they are reluctant to engage with it at an issue. In the letter replying to NGN's original letter about disclosure on December 7th, 2022, Prince Harry's lawyers didn't even address the issue of disclosure relating to constructive knowledge of Prince Harry prior to September 2013. In any event, it's not appropriate, in my judgment. In a case of this nature, for searches of documents and assessment of relevance to be left to Prince Harry personally, which is what appears to have happened until very recently. The contention of Mr. Batten in his evidence that knowledge of voicemail interception is irrelevant because those claims have been struck out is indicative of the problem that can arise with this issue, even if lawyers are fully involved. If searches have been conducted to date on the basis that only documents that relate specifically to the types of unlawful information gathering that are in issue are relevant to the knowledge issue, then that is much too narrow, as is the suggestion previously made, but apparently now abandoned by Prince Harry. The documents post-dating September 2013 cannot be relevant. Yet that position was still being maintained by Mr. Batten in his email of March 14, 2024. Apart from the articles about which Prince Harry originally complained in this claim and the documents that he chose to rely on in responding to the summary judgment application, Prince Harry has only disclosed 5 documents as being relevant to any of the issues for trial. Of these, only the documents previously relied on by him as evidence are relevant to the knowledge issue. That is rather remarkable and gives me cause for concern about the disclosure exercise. Remember, like in the 11th hour back in March, Prince Harry's lawyers came forward with additional information or evidence that they wanted entered in, which pissed the justice off because it was kind of like it came in at very last minute post this 2013, and that's what they were referring to. From the correspondence, it appears that Prince Harry and his lawyers tend to look at the disclosure exercise through the prism of the allegations made in Prince Harry's claim and not regarding the nature of NGN's defense. That is, perhaps why disclosure through the Practice Direction 57AC regime, which is otherwise appropriate in the business and property courts, would be more satisfactory now than the old standard disclosure, but that's a matter for another day. I've also seen troubling evidence to the effect that a large number of potentially relevant documents, confidential messages between Prince Harry and his ghostwriter of Spare, as well as all the drafts of Spare, were destroyed at some time between 2021 and 2023, well after this claim had been issued. The position is not wholly clear about what exactly happened, and it needs to be made so by a witness statement from Prince Harry himself explaining what happened to the signal messages between him and his ghostwriter and the drafts, and whether any attempts have been made to seek to retrieve them. Now, I believe this is 1000% a cover up because after Spare was published, there were articles coming out saying that Prince Harry has enough material that didn't make it in the first draft to write a second book. So for them to say all the drafts and text messages going back and forth had been deleted between 2021 and 2023, I don't buy it because they have been taunting people, or at least the Sussex PR machine has been taunting the family with this overt threat that Prince Harry will publish another book with additional details. I mean, if Prince Harry doesn't have it, they should subpoena, or if there is such a thing in the UK, subpoena the ghostwriter to give the information over. Whatever the case, if they really wanted to, there is a way to retrieve that. Governments do it all the time. So for Harry to pull this, oh, we deleted everything and don't have anything more about it, is a bold faced lie. It seems to me inherently likely that, in the course of discussing at length the material for Prince Harry's autobiography, matters would have been said that related to the parts of Spare in which unlawful information gathering in relation to newspapers is discussed. In short, it seems to me that the request for clarification of what had happened and for further searches and requests to be made, as set out in NGN's letter of March 8, 2024, were broadly justified. Mr. Sherborne argues that since this is an application for specific disclosure, the court must be satisfied that the disclosure sought is necessary for the fair disposal of the claim, not just that it is potentially relevant. However, it seems to me that correct standard disclosure has not been given by Prince Harry in this case because of artificial restrictions placed on the searches that were carried out in relation to the period for which the searches were carried out, the subject matter of the searches, and the material on which searches were carried out. This is therefore probably not a case where I should apply strictly the criterion of necessity, although, of course, I do bear in mind questions of the likely materiality of what is sought, the likelihood of its existing, and the cost and expense of any further searches and disclosure exercise. Now, I'm not really sure how billing is done with lawyers, but it appears here in the UK that costs are dictated by the justices. So, in order to get things done, such as this type of discovery and pulling information and doing the searches, there is cost assigned to it, of which the justice then makes that decision, which is what we see at the very end of this judgment or decision as to who is going to pay for what in this next phase in gathering this information. But in any event, where I do order further searches to be made in this judgment or steps to be taken to identify documents, I do consider that it is necessary for the fairness of the trial of the knowledge issue. It is one where Prince Harry is uniquely possessed of the relevant knowledge and documents, and NGN depends on full and proper disclosure having been given. I don't accept the suggestion that the fact that this application was not made before September 2023 or before the strikeout application was made shows that it's not necessary to order that disclosure now. The summary judgment application was made because NGN already had sufficient evidence of actual knowledge of voicemail interception. Had it not become fairly obvious from about the end of July 2023 that it was unlikely that Prince Harry's claim would be ready for trial by January 2024, I consider that this application would probably have been made before that trial. Following my request last week that the parties should meet to try to narrow the areas of dispute, NGN provided an amended version of the order that it seeks, and then, following Harbottle and Lewis' letter yesterday, a further amended version was circulated. That version seeks the following categories of relief. First, that Prince Harry's lawyers must carry out searches of electronic documents located on any of the following sources used or owned by Prince Harry: email accounts, laptops or PCs, other electronic devices, mobile telephones, including text messages, WhatsApp messages, and any other form of messaging, social media accounts, portable data storage devices, cloud storage location, and backup tapes. The category of searches, as originally sought and still sought today, is much too wide. But in the light of what has emerged and the evidence that is now in place, Mr. Hudson felt able to limit what he now seeks to 4 repositories of documents: Prince Harry's current and only laptop, any cloud storage of Prince Harry's texts and WhatsApp messages, the Signal platform to see if anything remains of the admitted messaging between Prince Harry and the ghostwriter, and 2 hard drives provided by the royal household to Prince Harry in 2020 at his request. So this clears up a lot. So those 2 hard drives are not servers. They're actually hard drives that were given to Prince Harry back in 2020 when he left with his relevant documents that he could take from the palace that belonged to him pertaining to whatever businesses that he carried over, which I would assume stuff for Invictus was on there. Things that I would imagine would be on those hard drives, obviously Beth Hurley's name as well as James Holt and the other people that they brought over from their team. Most likely contacts and PR access, as well as other details surrounding their foundation, getting that set up. Let's all not forget that Travelus was set up during that time in the UK, so I assume some of that stuff is also on those hard drives. I think it has a lot to do with the elements of leaving at the time, most likely, and probably his visa. I wouldn't doubt that visa information was also on those hard drives. The existing laptop has already been searched in relation to a few keywords for the period up to September 27, 2013. It is now sought to be searched over an extended period from 2005 to date, applying 47 different keywords with disclosure of any relevant documents identified. The laptop should clearly have been searched in this broader way, or something approaching it before. I accept the principle that simply because documents are not brought into existence until after or even well after September 2013 date, that does not mean that they are irrelevant to the knowledge issue. I think, however, the end date for any search can safely be January 2023, which was the date of publication of Spare. Mr. Batten gave evidence that Prince Harry has confirmed that he did not discuss unlawful information gathering by text or WhatsApp with anyone else and that there were no chats with the ghostwriter, either on Signal or in person, about unlawful information gathering. Exactly what Mr. Batten or Prince Harry, if he used the words meant by unlawful information gathering, is unclear. For example, does it relate to all kinds of unlawful information gathering or only those in respect of which Prince Harry still has a claim? The position is unclear. This is the problem, where evidence of such a fact-sensitive matter is given by a lawyer, not of exactly what the client told him, but of the effect of what was said, as he understood it. Further, the suggestion that there was no discussion by text is apparently contradicted by the ghostwriter in the article he wrote in The New Yorker, where he says, "We were texting around the clock." So here's the thing, though. We all know that Meghan had influence on this book Spare, and no doubt, allegedly, had been engaged with the ghostwriter as well. So why is there not a suggestion to go ahead and search her laptop now for information going back and forth with the ghostwriter? Don't you think that Prince Harry was having his wife on her laptop communicate as he's like mucking around? Seeing how Meghan is so controlling over Harry, you don't think that the 3 of them didn't have their own little WhatsApp chat group? They need to think like that and search her as well. It is possible that he used the word texting there as a synonym for messaging, either generally or Signal messaging specifically, but that's far from clear. Regardless of that narrow issue, I accept that it's appropriate in a case of this kind that turns on what Prince Harry knew or what he could have known at a particular time for his text messages and WhatsApp to have been searched. It should have been done as part of standard disclosure, regardless of what Prince Harry might have thought he could remember about which media he used to discuss various matters. I will therefore direct a search of those repositories using the same search terms and over the same time period as the laptop. For what it's worth, I agree that an attempt should be made to retrieve the signal messages that are believed to have been deleted, and, as I've said, Prince Harry must make a witness statement explaining the circumstances in which the deletions of those messages and the destruction of the drafts or other documents took place after the commencement of these proceedings. As for the hard drives, I do not accept there is sufficient likelihood of documents relating to Prince Harry's knowledge about relevant matters to be on documents on a shared drive used for business rather than personal purposes. The evidence of Mr. Batten and the screenshot of the menu of files and subfiles on the drive appear to show that it is business related. And this is where you find the UK court system as being naive and not fully thorough. So they're giving Prince Harry the benefit of the doubt when already he has proven himself to be all over the place and inconsistent. So his facts or his truth that are being pulled out already have been debunked and as well disregarded. So why are they not thinking a little bit more sharp to cover all their bases because these two are so deceitful? I'm sure Megan already thought about this and is 5 steps ahead with having her drives wiped, cleaned, and most likely thrown in a vat of bleach. Megan may not be academically smart, but I can say that she is criminally smart or crooked smart and emanates from his office. While it is not impossible that there might be something of relevance, the likelihood, it seems to me, is less, and searching those drives in addition to the personal email account, texts, and WhatsApps would be disproportionate. If the hard drives do, as Harbottle and Lewis assert, but Prince Harry denies, include cloud repositories, then the texts and WhatsApps are covered in any event by the specific order that I have made in relation to them. Ultimately, Mr. Hudson did not press for any other specific order under paragraph 1A, and I declined to make any other order in the general terms sought. The second category, paragraph 1C of the draft order in its latest formulation, seeks an order that Prince Harry's lawyers send letters to Harbottle and Lewis by a specified time after the order, in which they, 1, ask Harbottle and Lewis to provide Clintons within 21 days with hard copy and electronic documents held by Harbottle and Lewis in its client files for and or in relation to its representation of Prince Harry, and 2, asked the royal household, Sir Clive Alderton and Sir Michael Stevens, to provide within 21 days hard copy and electronic documents held by the royal household, which record or contain communications which relate to allegations of voicemail interception and or unlawful information gathering relating to Prince Harry. In the light of recent correspondence, including Harbottle and Lewis's letter of yesterday, which is far from helpful to NGN in terms of willingness to assist, I initially formed the view that for Prince Harry to be ordered to write a further letter in those or similar terms was pointless, as it would be met inevitably with the same robust response. Mr. Sherborne says that I was right from that view, pointing out that this would be not the first letter written to Harbottle and Lewis asking for that, but the third. The first letter, he said, was a letter dated April 30th, 2024, which Mr. Batten describes as a request that Mr. Tyrrell of that firm carry out searches as requested in NGN's original draft order of documents held by its firm in relation to its representation of Prince Harry and the royal family. However, privilege is claimed over that letter and it has not been produced to the court. So, in what context exactly that was asked for is uncertain. So, essentially, NGN wants documents or files pertaining to Prince Harry as the client for Harbottle and Lewis while he was a royal. And being that he was HRH and part of the royal household, I think privilege, meaning they don't have to disclose that because he was at the time a royal member of the family. And I can see the position of the royal family because this inquiry in getting documents of client Prince Harry could actually expose the firm further to other things, and that's a risk that they want to mitigate, rightfully so, to protect the brand. The second letter Mr. Sherborne identified was the letter of June 24th, 2024. This asks for confirmation of whether the royal household has any hard copy or electronic documents recording or containing communications sent to or by or on behalf of the claimant, Prince Harry. These two letters were therefore not requests by Prince Harry as client or owner for documents relating to his affairs or his documents to be provided to him. That seems to me to be a quite different kind of request in principle, to which it is difficult to see what a lawyer's objection could be unless their fees remain unpaid. I therefore agree with NGN that there is a purpose in writing such a letter because it may result in any relevant documents held by Harbottle and Lewis being provided to Prince Harry's current lawyers, when they can be searched, identified for relevance, and then any proper claim for privilege made. If that were done, there would apparently be no need for the non party disclosure application against Harbottle and Lewis to continue. It is therefore proportionate for a short letter to be written to Harbottle and Lewis, which might well avoid the necessity for a further substantial hearing. I add only that the documents likely to be identified by such a request, if they are produced, will very likely relate to Harbottle and Lewis's representation of Prince Harry for his intended claim against the NGN newspaper from 2012 onwards, and therefore are plainly likely to be highly material to a fair trial of the knowledge issue. I will therefore make that order as sought. As for the letter to the royal household, the terms in which that is now sought are much reduced from the original draft order, thereby dealing with the principal objection that Harbottle and Lewis made on behalf of the royal household, namely, the breadth of the production that was being sought. No letter has previously been written to members of the royal household or Harbottle and Lewis on their behalf asking for Prince Harry's own documents to be given to him or his lawyers. Again, I do not consider that such a letter would be pointless. It may bring clarity to the question of what documents exist, to whom they belong, and whether there is another proper reason for refusal to hand them over. Again, it may negate the necessity for a further hearing of the non party disclosure application to be made, and I will therefore make that order too. It is not in dispute that if I make any of the substantive orders sought, then the ancillary orders, which I think are paragraphs 1D and E and number 3 and number 4 of the draft, should also be made, and I will make those too. So these are the orders the justice brings down based on the application that NGN had submitted for getting this discovery or data collection. And what happens next is the breakdown of costs and where he agrees that NGN has the right to do what they're asking, and then also where he is limiting the scope of what they would be looking at. And he breaks it down to where Prince Harry now has to pay 2/3 the cost for this data search and sending out letters and so forth in this court case. Now, I'm not fully sure if I understand this correctly, but in the United States, what normally would happen is law firms would go ahead and do whatever discovery, if moved into that phase, and would bill back the client for the time that they spent to do it. So this is why, like, when judgments are made in our court cases, it's based off of the whole estimate, let's say, for what it costs to go ahead and do these discoveries and searches and little things such as photocopying and prints and submitting for other things, as well as doing depositions. All of that stuff costs money. So it does appear that it's a little bit different in the UK, in which the judge makes the decision on whether or not they get to go ahead and do these types of searches. And then once it's ordered, This cost that's associated is what Prince Harry is now going to have to pay for NGN because they are ruling in NGN's favor for 2/3 of it. So here's what the cost to all of this says. I have to determine now the cost of NGN's application. The first question is whether I can identify who has been the successful party. I can, and the successful party to my mind is undoubtedly NGN, although it has not succeeded on the whole of its application. The next question for me then is whether to make some different order or adjustment to the order for costs that would otherwise be made that the unsuccessful party pay the successful party's costs. Mr. Hudson, frankly and straightforwardly, recognizes that it can be said that there has been a significant degree to which NGN has not achieved what it set out to achieve. The draft order attached to the application notice sought at paragraph 1A the same relief as has pursued right up until today, when its scope was reduced quite significantly in the course of argument this morning. Paragraphs 1B and 1C are different form of relief, but essentially similar to the relief that has been pursued at the hearing today in relation to documents relating to Prince Harry held by Harbottle and Lewis and the royal household. Although, in both cases, the relief originally sought was significantly more extensive than that which I have eventually granted. The description and the categories were cut down as a result of observations made by Harbottle and Lewis as to the surprising breadth of the orders that were being sought. Paragraph 1D was an application to search documents held by Clintons in their files. That was a matter that has not been pursued. I agree with Mr. Sherborne to the extent that he says that NGN framed its application too broadly, and I consider that there should be some adjustment to reflect that. In addition to the breadth of the relief that was sought and not obtained, there is a question of prematurity. The application was issued on April 4th, following a letter written by NGN solicitors on March 18th asking for various confirmations to be given and warnings that an application might be made. A holding response was sent on March 26 by Prince Harry's lawyers saying they would respond shortly. On April 4th, the application was issued in any event, and the response from Prince Harry's lawyer's response did not come until May 3rd, a month later. In my view, NGN was justified in deciding that the time had come where an application should be made. There had been previous correspondence which took a great deal of time to progress, and not much progress had been made. The assessment that the defendant, NGN, should not wait longer was not an unreasonable one, given that this matter obviously had to be heard before the summer vacation. But in any event, regardless of prematurity, if NGN had waited until May 3rd for Prince Harry's lawyers to respond, they would still have been in the position of needing to issue the application to obtain the relief that they have succeeded in obtaining today. Therefore, it seems to me that the prematurity point goes nowhere. Further points made by Mr. Sherborne are that, as of last Friday, a further head of relief sought was introduced into the draft order relating to the documents that were sent by the royal household to Prince Harry in 2020. And then, after explanations were provided about what those documents comprised, only a small part of the application was pursued, which in the end was unsuccessful. I don't find fault with NGN for introducing the new head of relief sought because it arose from a letter of June 11th that they could not have predicted. But it's fair to say that a further point was raised and it was then either abandoned or not succeeded on. So that is another more minor point in Prince Harry's favor. It is then suggested that in relation to the costs of seeking orders that letters be written to Harbottle and Lewis and the royal household, I should not make any order for costs until we wait and see whether those letters produce any response. The implication being that if they don't, it was all a waste of time and they should not have their costs. I'm not at all attracted to that approach. First, because NGN succeeded in the argument and in obtaining the orders that it has been seeking, at least since last Friday. And secondly, because taking the approach that Mr. Sherborne urges would only create a kind of perverse incentive for the recipients of the letters to do nothing and thereby influence what the likely outcome of the cost exercise will be. That strikes me as wrong in principle, and I don't think that any adjustment should be made in relation to the costs of that relief. Looking at the matter in overall terms, therefore, taking account of the extent to which NGN has not succeeded on its application, including both the original wording of the order and the new point introduced, it seems to me that the fair order in the circumstances is that Prince Harry should pay NGN 2/3 of the costs of the application to be assessed on the standard basis, if not agreed. So, after going through this and really digesting what the justice had said, I think the reason why Meghan and Harry chose to deflect this news of him destroying these WhatsApp messages and signal messages between his ghostwriter is probably in the communication back and forth between him and possibly even Meghan. It might be showing communication surrounding of how this is a grift, a genuine grift, and maybe Prince Harry could have had conversation by saying, "Well, we did talk about it back then, but I wasn't affected as badly as William or my girlfriend at the time." There could be things in there that he disclosed, and it makes Prince Harry look like, well, he did know about it and could jeopardize his case. But what if there is a possibility that David Sherborne is a part of some of these communication messages? Let's not forget that in Spare, Harry talks about meeting David Sherborne down at the south of France. And who knows, maybe there was conversation going back and forth, and David Sherborne being a part of it to help craft this narrative, to help paint the picture. That could be very incriminating, in my opinion. So, when you look at Harry destroying all those messages and drafts of Spare, I guarantee there's something that ties back to this court case and the discussions around how to formulate the narrative around it. And that's why I think possibly this is why Harry destroyed it. Just my opinion. But what do you guys think? As always, definitely leave your thoughts below. I will be back with more content, but until then, please be safe and I'll talk to you later. Bye.
Such a fraud.